Good. Sorry.
And we're taking up first the emergency bill remote deed recording. And I believe there's also powers of attorney. And this will be part of a package of civil legislation that will be put forth. Excuse me, and I'll turn it over to Eric and then Terry Corsones.
All right. Thanks, Senator Sears. This is Eric Fitzpatrick with the Office of Legislative Counsel, talking about some proposed legislation that the committee is considering regarding remote notarization of deeds and powers of attorney. As you mentioned, Senator Sears, the deeds language was before the committee. I think it was Tuesday that we met earlier this week. And in addition, since then, there's been another issue raised having to do with powers of attorney. And the reason that these are here before the committee now, you may recall, with respect to the witnessing of wills and notarization of wills language that you passed on Tuesday, and that then passed the Senate in S-316. The issue was that notarization of some of these official documents requires that the notarization be done in the presence of the notary and sometimes in the presence of witnesses as well. But the physical presence requirement has become very challenging during the pandemic because people either don't want to travel, they're afraid to travel, or to be in the same place with a number of other people to execute these documents. So the big picture on that is that essentially the language that you have in front of you, if you had a chance to look at it yet, very, very similar to the language that you already passed with respect to the remote notarization of wills.
Yep.
You know, the concept is the same, which is that if the notarization is done in consistency and in conformity with the emergency remote notarization wills. Remember, we talked about those earlier in the week as well, that the Secretary of State's office is putting out. And I have heard now that they were adopted on Wednesday. So the rules have been adopted. If the notarization is done in compliance with those rules, then physical presence is not required. It's the same concept that you had in the wills. It now would be essentially the same concept with respect to powers of attorney. So for example, you're executing a power of attorney that allows someone to make decisions on behalf of the principal, decisions about selling property, about, they can be healthcare decisions. Those requirements that the document be notarized in the presence of the notary, the physical presence of the notary, would be subject to these emergency rules. So, and those would allow, and I actually put on the website, if anybody wants to look at it, Secretary of State's office has been working on some guidance. So how this is going to work. And so it's a draft version of it. It's not the final version. I should mention that I think even last night that Terry and members of the Bar Association and others have been going back and forth with the Secretary of State's office to get this language finalized. So this is not the final version, but it is helpful to at least take a look at and see how detailed it is. And I just wanted to just mention one point because you had referred to the Senator Sears, I think, when you were reporting S-316, which is that it has to comply, this remote notarization procedure has to comply with this setup in the rules. And as the guidance describes, remember, Senator Sears, the notion of a secure communication link. So that's how this remote notarization has to happen. And there's some specifics about that, a definition of that in the rules and in the guidance, which is very helpful. It says that it has to allow for direct real-time interaction between the principal, the signer, and the notary. It has to be of such quality that clear visual observation of the face of each participant and clear visual observation of the identification being provided, because the person has to identify themselves. It's interesting the way the rules written. If the two people know each other and they recognize each other sufficiently, then I don't think the identification is required. But if they don't, then you have to put something up like a driver's license or something like that that identifies you as who you assert to be. As you mentioned, there's an audio visual function. So it can't just be audio, it has to be audio visual, and it can't be pre-recorded. So you have this lengthy list of rules and guidance that is still being worked on. And I think there, as I say, the language is being worked on literally today. But the bottom line is that if the procedure complies with that remote notarization rule, then the notaries can use this secure communications link rather than having to be in the physical presence of each other. So if you look at those statutes, the language that's in the two amendments you have before you, both the powers of attorney and the deed witnessing both say physical presence. They were, acknowledged in the presence of the notary. So under the rule, that video remote secure communication link would be permitted.
Okay. Eric,
That's
just
the big
so it's
picture.
clear to me and anybody who may be listening in, none of this is effective in terms of the deeds, the wills, or the power of attorney until the Secretary of State does his rules and until the governor signs a bill. Am I correct?
That's correct, Senator Sears. And also, that's a good point. I wanted to add that you were pointing out when we met on Tuesday with respect to the deeds, at least, that the way the deeds language had been written originally, it was not limited to the time period that those emergency rules were in effect. And it also sort of incorporated by reference the potential for some federal permission of remote notarization. So those two pieces have been struck to make it, and so instead it's very much parallel to the wills piece. So it has to be done while the emergency rules are in effect, and it's only references those Vermont rules rather than anything from anywhere else.
Okay. Any questions for Eric on the committee?
I was just going to add one more sentence, one more piece if I could. You'll see there's one other piece added to both bills that is basically saying, and I think Terry will be able to talk about this a little bit more, but it came up during their discussions with Chris Winters at the Secretary of State's office, that it would be important to include in statute some language that provided that if the document is executed in compliance with these emergency rules, then it will be presumed valid in the future, so that if litigation came up, if there were challenges around the authenticity or the validity of the document, that you'd have statutory language saying that, well, if the rules were followed, then there's a presumption that they're valid. And that presumption could always be overcome, of course, if there was some evidence to the contrary, but at least there'd be a presumption.
Alice?
Eric, can I ask a question?
Yes.
You guys, can I interrupt for 1 second? I apologize. I just got an email from IT and they said they're listening to the live streaming. There's lots of noise in the background and they asked that everybody self-mute unless you're speaking.
Everybody do what?
Sounds like somebody's doing dishes. Yeah.
What do you want us to do?
Well, Senator White, for you to self-mute, you have to press *6.
I know. I have a mute button. I can mute myself.
Okay.
They're I have to press *6.
Yep. And all of you guys that are on Zoom, you just have to go to the corner, the right corner of where your tile is, and press mute. Because they said it's really difficult for people to hear, and I know there's a lot of people listening.
But should we press?
Can I ask a question before we do that?
Yep. So in the right corner where your tile is, there's like 3 dots. If you press that, that gives you the option to mute.
Okay. But you can't press mute if you're talking.
No,
you're talking.
You have to unmute, but if you're talking, you unmute yourself. But everybody else should mute themselves if they can.
Thank you, Peggy. Go ahead, Eric.
No, that was my same question, Senator. I think Senator Nitka has a question, or Senator White.
I have. Yes,
Senator White does.
Nitka does too. I'm just wondering. We're doing all this. It sounds like the Secretary of State has already gone forward with all this, and what you're saying is they can't do this without us. They can't do what they want to do without us doing this. Is that correct?
No, I think it's the opposite. They can go ahead and do what they're going to do, but these statutory changes bring the statutes into conformity with their rules.
I see. And is it clear that, can I ask another question? Is it clear when the emergency is over that this will no longer be in place?
Yes.
Yes.
Okay. And let's see.
May I?
Okay, that's my question.
Jeanette?
Okay. So just on the first page there on lines 20 and 21, who attaches the affirmative statement? I don't quite get how that works.
That's the person executing the document, and the affirmative, that's actually a reference to something that's in the rules. That
Okay.
that certificate is a requirement of the rules, that a person doing one of these notarial documents remotely has to include a certificate that the procedures of the rules were followed. So what that's saying
Okay.
is, and that's the new sentence that I was referring to earlier, what that's saying is that you have to take that certificate and attach it to it. And if that certificate, which is saying all the rules were complied with when this remote notarization process occurred, then it will be presumed valid in the future.
Okay, thank you.
Yep.
Okay, everybody
So
good? Terry?
May I ask
I'm not,
one more question?
Okay.
Me? Is
Whoever
the
has it.
Secretary of State with us right now?
Huh?
So,
is the Secretary of State on the line?
No, the Secretary of State is not on the line.
okay, because what we heard in GovOps was that they were doing the emergency rules, and we don't have to do anything more in there, right? Because they're doing the emergency rules, and then we're doing this in here. So we don't have to do anything more in GovOps.
No, I wouldn't think
Okay.
so.
No, I think
Okay.
that's correct, Senator White.
Okay, thank you.
Terry, did you want to comment, and then Judge Grierson?
Yeah, no, I have nothing to add to what Eric said, although Eric, it's my understanding that the emergency notarization rules have been issued, that the Secretary of State has done the steps to have them issued.
Yes, I heard that too. I think it was Wednesday.
Okay, and then we're just working on the guidance with them, which hopefully will be coming out shortly just to give guidance, but otherwise you explained it very nicely.
Judge Grierson, any comments? Oh, you gotta unmute yourself. The judge is still muted.
Yes, okay. No, I do not have any comments. Thank you, Senator.
Thank you. Eric and Terry, thank you very much. And Judge, what I plan to do is next Tuesday is look at a final draft of these two things, plus the statute of limitations that Bryn's working on.
Okay.
That's what I was wondering, Senator Sears. Just should I incorporate these into a separate bill, or what your thoughts were on that?
Well, I thought we would do two separate bills, one on the civil side and one on the criminal, that Judge Grierson's emergency order, or would do one big bill. I don't care. I think it's probably easier to do one big bill for everybody.
And is this going to be a committee bill, or?
I think it's easier to just take some Senate bill that's still on the wall and pass it. I need to check with Senator Ash how they want to do that.
Okay.
Can
For
I
right
ask?
now, it's XXX.
Right.
Can I ask, what's the statute of limitations bill that Bryn's working on?
Well, I believe it's a request from the bars, from certain attorneys who would like to see
A stay?
a stay of all statute of limitations. I believe that Bryn would be better to speak if she's still with us, but I believe that New York, the governor there did it by an emergency order, that all statute of limitations were, I don't know how it reads. If Bryn's still here, she could probably explain it.
Yeah, no, I can follow up with her after.
I'll send you an email, Judge.
Thank you very much, Bryn.
Oh, Bryn, you're there. Good.
Yeah.
Thank you.
Okay, thank you all. So is Steve Howard available yet?
Wasn't aware that he was coming on. There are two numbers that are unidentified. One ends with 025, another with 032. If you can tell me who you are, please.
It's
Pepper and John Campbell.
Yeah. Okay, you both talked at once.
All right, 9025 is Pepper.
Okay.
Okay, well, I
And
had scheduled,
003.
I had scheduled Woodside at, there might be some confusion. I thought like 120. And,
That's what I told them.
yeah. So I don't know if they're having a hard time getting in or why they aren't there.
These are challenging times.
Well, they are.
Hello, Senator.
Hello,
Hi,
is this Steve?
that's me.
Oh, good.
It says Amy.
Oh, Amy Kinsel, right.
All right, Amy, go ahead. I can see you now, Steve.
Yeah.
I want to explain that this is, it's not really Woodside. I don't know what you call it anymore. As you all know, we moved the, we didn't do it. They moved the kids from Woodside to St. Albans to a house up there or building, I don't know. And we had some testimony from Commissioner Schatz about it the other day. Next week, we'll have a joint hearing with Senate Health and Welfare at one of the days, maybe Wednesday, and hear from DCF and DMH on this move, and any others who want to be involved. But I thought I'd give Steve Howard a chance to comment on behalf of the employees who been, I don't know if have all the employees been moved there or some of them are still Woodside, or maybe you can help us with that, Steve. Go ahead.
I think they haven't moved to Woodside. I just got off the phone with them, and I think, first of all, thank you, Senator, for the opportunity. And I also just want to thank the members of the committee for raising some of the concerns that they heard from our members at Woodside. I did, right after your last hearing, have a very productive conversation with the commissioner about some of their concerns, and some of them have been addressed. They have figured out some of the logistical concerns. I think the first thing that our members wanted to stress is that despite the chaos and the sort of abrupt change, I mean, our members at Woodside have been through an awful lot this year and recently, that they are 100% committed to making this work and taking care of the youth that they have there at this new facility, and they hope for the resources and the support that they need to do that. Some of the questions that I think are being addressed that are just, I think, percolating out there. One is a security concern. I do understand from the commissioner. I don't think this has happened yet, but you know, the facility is not it's a staff secure facility. So the doors don't have alarms on them yet. The windows don't have locks on them yet. And it's not just a concern about the youth leaving the facility, which is a concern, but another concern about people finding out where this facility is and being able to access it from external forces. So people who have a beef with somebody who's there or are mad at the staff who are there. So security is an issue. I think the department has addressed the lack of rooms to sleep in and shower space for the staff with hotel rooms down in in St. Albans. I think one big concern that they have, and I think this is a chaotic moment, and they understand that. This is a very different program than what they had previously at Woodside. There is a lot of commitment from the leaders there to roll out what the program is supposed to look like now. It's a little confusing because they have, in the last 3 months, they've had 3 different leaders. And they have a new leader now, and hopefully somehow they will be able to get some clarity on what the program is there. I think to sum it up, what our members are doing, and I think a lot of people are doing this these days, is they are basically just winging it until they get some guidance from someone about how this program is supposed to operate. There is a tiny rec yard there. It's shared space with other organizations that are there. They can see that that's going to be a problem. I know that DCF is adding some recreational capacity. They are nervous that this confinement issue and the lack of activities to keep kids busy might result in some problems. I do think we got the food situation resolved, but like anything else in state government, we are also very concerned about getting protective equipment, not only to all of the state employees across the state who don't have protective equipment, but also to our folks working at Woodside in what is very close quarters compared to what they had at the original facility. So I think those are basically the things that they wanted to stress. I think one of the things they just really want to say that they're not exactly happy with the abrupt nature of how this happened, but they are committed to making it work, and that they understand that these kids are their first priority, and they will make sure that they remain so.
Well, thank you, Steve. Are there questions for Steve?
Alice,
Steve?
I have a question.
Yes, Alice.
How many employees are now involved in the new facility?
I don't know that. I would have to get that information from DCF, Senator, but I will get that for you. Do you mean on each
Thank
shift,
you.
or do you mean in total?
Total, and do they have enough on each shift? Just total number. And
Okay. I will get that information, Senator, and get that to the committee.
It's a good question,
you.
Allison. I guess one of my questions, and I expressed this to Commissioner Schatz and to you earlier, and it boggles my mind while we're still having sleeping shifts there, why that would be. It's a much smaller building, and so I don't understand that. So that's one question. The second is, in terms of the security, when we opened 206 Depot sometime in the, I'm gonna say 90s, because I don't remember exactly when we bought that building, but one of the first, and it was pretty easy, just put in alarms. So you knew if somebody opened the window or opened the door, the alarm went off, and we were staff secure. Questions always asked, and I don't know if DCF has an answer or will have for next week, but I guess the question is, when a kid is going out the window, do you stop him or do you let him or her go? And I think that's one thing. I think at Woodside, it was a little less likely, given the security there. And that would be a question that I think needs to be answered for the staff. I don't know the answer to that.
So, Senator, I can say that, I don't know if DCF will agree with this, but what I was told by our staff is that if somebody does attempt to leave, that their instructions are to call the St. Albans police and describe to the St. Albans police what the kid is wearing, and let the St. Albans police apprehend the kid. And we assume bring them back, because there's no other place to put them. I mean, one thing that really is important is that the kids that are there, and I think there were 4 or 5 kids there, they were sent to a secure facility. So this is not a secure facility, but I do understand from what the commissioner said to me yesterday is that they are adding the alarms on the doors, and they will be putting locks on the windows. There is a lot of concern about the amount of glass. There are glass doors that need to be replaced. Both not solely from the perspective of concern about the kids getting out, but of other people trying to get to those kids being able to get in.
Well, Deputy Commissioner Johnson is here, and I'm sure that she's taking the comments down as well. We'll have some answers for next week too. Steve, are any other committee members have questions about this? I understand. I mean, I can't imagine how quickly this whole thing happened, and change is always difficult, especially when you've got all the other things going on regarding the coronavirus and et cetera. And that does create anxiety both for the kids and for the staff, I'm sure.
So I have one more question, Alice.
Sure, Alice.
I'm just wondering, so if there's a need for placements outside there in our communities around the state for the service that Woodside was providing previously, will they be able to go into this placement?
Senator, respectfully, that may be a question for DCF.
Okay.
My understanding is that they can, but I'll let DCF take that question.
Okay, thank you.
Did Christine, if you wanted to answer that question now, or if you have an answer. We can't hear you.
Is that better? Can you hear me now?
Yeah.
Yes.
Okay, good. So Alice, I'm not sure that I understand your question.
In other words, someone out in the community now commits an offense that would have maybe allowed them to go to Woodside. Will they, and that happens, will they be able to go into the St. Albans facility? You know,
Yes.
if they meet all the criteria and you need a placement.
Yes, they will. That's correct.
Yes, okay, okay. Thank you.
You're welcome.
Anything else, Steve, from your?
Nope, that's all I've got. Thank you, Senator.
Well, I appreciate you taking the time with us, and these are difficult times for everyone, and I know I'm hearing quite a bit regarding at the Veterans Home as well, and I hope that maybe you and I and Senator Campion could have a call with some people from the VSEA about that. I don't know what we can do. I know they're very concerned about the lack of personal protective equipment down there.
Right. Be happy to do that, Senator.
I would appreciate that.
All right.
All right.
Thank you. Thank you very much.
Thank you. All right. The next issue is Judge Grierson.
Senator Sears, may I ask a question before Steve leaves?
Yeah, Steve, I think he's gone, but.
Oh, okay. I was going,
Christine's
it wasn't
still
really
here.
a question. I was just going to say that we are tomorrow looking at VSEA issues, or this afternoon looking at VSEA issues. We're just getting a list of them, but we will just leave, because we deal with state employees, but we will just leave the whole Woodside conversation in Judiciary.
Okay, but I hope you will. There's a lot of concern, obviously, in any nursing home, and since state employees work at the Vermont Veterans Home, they're really concerned about the lack of masks and other personal protective equipment.
Yeah, we're going to hear some of the issues tomorrow. I mean,
Good.
today.
Good. Thank you, Jeanette. Judge, we've gone over your proposal a little bit and haven't heard from the other players. I don't know if there's, I've got to now look up your proposal again.
Which one is it?
It's the, and maybe if,
It's on your legislative page. It's under my name and it's a memorandum.
you have to go to the Judiciary Committee page. It says memorandum. I don't know if Senate Judiciary.
Yeah.
Is it two joint rules?
It's the same.
Are we on the D? Is this?
No,
is
this
this
is
the
on
Judiciary
the
proposal?
on the emergency,
Yes.
the emergency legislative changes.
Yep.
I believe that
So
we got it on the 23rd, so it might be on the 23rd.
So when I click on that, I see this.
Judge Grierson
Senate's
emergency. If you go to the 23rd of March.
Oh, geez, I can't get
click
there.
on
How about on
23rd of
today's?
March, and it says
It's also
Today,
posted today.
it's also today. I'm on the earlier one.
Okay.
And
So I
Judge
see
Grierson-
proposed emergency legislative changes. Is that
That's
it?
And we
The
went over.
sentence review?
Yeah,
Yes.
we got, as I remember it, we went over it. And we ended at landlord tenant. I think we were right there, Judge, on your landlord tenant on page 2.
Right.
If I'm not mistaken.
I think you're right.
That we didn't discuss that. And that
We did.
we did discuss it, or we didn't?
No, I think we did. It was just simply a change from
Okay.
shall to may, which would
Right.
give the court
Oh, yeah.
discretion on how much rent would be accumulating.
So I guess I would then, do you have anything to add, Judge, at this time?
Not on the landlord tenant.
What about on the sentence review?
Sentence review, as I said the other day, Senator, sentence review right now, we can review a sentence within 90 days of a sentence being imposed. The language that we have proposed here would allow us to review sentences after 90 days, but only with the agreement of the prosecution and the defense. In other words, this isn't the court usurping anyone's authority. And I'll give you an example. There was a case in Barry just this week where a fellow was due to be, he was serving a sentence. He was due to be released, I want to say mid-April. And both the state and the defense agreed that there was no point in leaving him there under the circumstances. It turns out that that case came within the 90-day threshold, so the attorneys agreed to a resentence that would allow him to be released today or this weekend. So it worked because it came within the 90 days. But if this same fellow who was due to be released in 2 weeks, if it was beyond 90 days from sentence, we could not change his sentence. So this is just to give, quite frankly, not the court, but the parties, the attorneys, more flexibility with some of these folks who are incarcerated due to get out, and would allow them to get out if they agree. If they don't agree, then it would not give us any authority.
Can I interrupt for a minute? I thought in our last meeting, we decided against this.
Oh, I don't
think so.
I think.
Well,
I
we
don't
had quite
remember.
Dick,
I
I
don't
think
had quite a discussion about it.
We did, but I think we wanted to hear from all the parties.
I think the decision was to not put it in what we were doing this past week, but
Yes.
to defer it to now.
Oh, okay. All right.
So we would
That's
hear
right.
from the defense, the attorney general, the state attorneys and corrections. But this is a permanent change, am I correct?
Well, Senator, this is a policy decision. I think there's a place for it with or without the emergency setting, but if that either way would be fine.
Okay.
But I think there's some discussion, had been discussion about this even before this pandemic came on us. So
I wouldn't think we'd want it in a bill that we want to pass.
You mean as a permanent thing?
Yeah, where are we doing that now?
Or how about during this pandemic?
Alice, before we decide, it might be helpful to hear from the other witnesses.
Okay.
And Senator, do you wish to hear from the other witnesses on each piece, or do you want me to go through the whole bill?
No, I think we've been through the whole bill.
So the next piece is the Rule 43 changes.
Okay.
That will allow us to continue to use video. And I do have some suggested language. If the committee supports this, I will get that language to Eric or Bryn, who's ever working on this.
Okay.
It essentially says that the presence of the defendant will be deemed to be.
Somehow we've got somebody on speakerphone.
So you're getting an echo. But anyway, if the committee's interested, I can provide that language to Eric or Bryn.
Yes.
The other ones, bail review is, we're supposed to have bail review hearings in 48 hours, review conditions of release in 5 days. We're just finding that in this environment, we can't meet those deadlines. And I would think if they were extended to 7 and 14 days respectively, we could fit into those timeframes. On mental health, again, it's a, I don't know why we're getting feedback, but I'll continue to talk. Again, it's difficult to meet those timeframes in today's environment. I will tell you that we're working very closely with the Department of Mental Health and the Attorney General's office to try to do as many of these proceedings by video as we can, which may allow us to speed up the process. But again, I'm suggesting we go to 14 days as a temporary measure to get those scheduled. The civil suspensions, again, is a matter of if these cases aren't being heard. Suggesting that moving the deadlines. Expungement and sealing, I won't spend much time on that, except that it's clearly not a priority during this time. And we would ask that any time frames be suspended while this emergency is in place.
Okay. All right, and that is the whole bill.
It is.
Okay, next, any questions for Judge Grierson?
I do have a question.
Bill?
Judge Grierson, I'm just wondering, is this limited exclusively to reducing sentences?
Well, it's driven, you're talking about the first piece.
Yes.
I take it. So it's driven by what we have been seeing in the courts and, reading newspapers and reports, Department of Corrections, prosecutors, defense attorneys. There are certain individuals who are under sentence that could be released. Everyone agrees it could be released, except the sentence structure itself is preventing them from being released. In other words, these are people that are not getting programming. They're essentially doing dead time, and they're going to be released, some of them in a relatively short time, but there's no way to restructure a sentence. They're not eligible for furlough.
I do understand that. What I meant was, does it exclude the possibility that somebody's sentence could be made harsher?
Harsher?
Yes, longer.
No, the short answer is no, because no one's going to agree to that.
Well, personally, I would like the legislation to be written to eliminate that as a possibility, that everybody could agree that the sentence be lengthened. Because
I'm sorry, the sentence what?
If I understand what this says, it says with agreement of the parties, it could be, the sentence could be modified.
Could be modified to release the person.
Only to release them.
That would be the only reason the parties would agree to modify the sentence, I would think.
Okay.
But
yeah, I suppose it's in a range of concerns that I would situate Alice's concern to. In other words, wanting to limit this and to make sure it's very focused in terms of time, but also in what it allows in terms of modification.
I understand the concern, Senator, and that's why if you look at the language, this is more of a reaction to what I'm seeing, what the judges, courts are seeing in this period of an emergency, and it's only designed to work if the real parties in play, the state's attorney and the defense agree on this. Otherwise, the person's sentence will remain as it is.
Yeah.
As is.
Yeah, I was just reacting because it said reduce or otherwise modify, which seemed a little broad.
Well, certainly the language, if other folks, I'm not sure how other parties feel about it. If we can't agree on language, then obviously it's not going to go through.
Okay.
I'm amenable to any changes. I'm just trying to make this work from what I've seen or what the concerns are with some of the people that are incarcerated that probably are going to be coming into the community. And so this is a process to shorten. But I think if you hear from the other parties.
Yeah, I'm happy to hear from the other parties, but I want to make expressly clear that if somebody's coming out, they need to make sure, they're coming out in very difficult times. And jobs may not be available, housing may not be available, all of those other things. And I really am concerned about that. If we're just trying to unload people out of the correction facilities, it's one thing if somebody's on bail and we change the bail conditions or whatever, but quite another if they've been sentenced, been in for a year or 2 years, and now they're coming out at this particular time. I can't think of any time worse to come out particularly if you're a person without structure. So, but if Matt, if you could unmute yourself.
Judge, before Matt comes on, I just want to make sure I know your position. This current proposal is being presented at a time when there's a declaration of emergency. Are you of the opinion this should be limited to the time where there is a declared emergency, or is this a permanent rule you wish to have placed into concrete?
You know, Senator, that's, I guess, a difficult question for me to answer for this reason. I have heard in practice that when beyond the 90-day period currently, there are some situations that are brought to the court's attention, and parties agree that a sentence can be restructured for one reason or another, essentially re-sentence. And what I'm hearing, and I guess I've probably experienced it, some judges say no because it's beyond the 90 days. Others, because the parties agree, sometimes agree to a change in a sentence structure. So I think to some extent, not a great extent, but to some extent it happens. So I think under some circumstances, there is a place for this language even beyond the emergency, but I'm not here with this proposal advocating for this, other than this is what I'm hearing in under these circumstances, that there's a place for this. If the committee decides not to take it up, we're going to continue to operate within the parameters that we have.
Okay,
I
I'm
think
going
there's
to
a
ask
place.
this of the, I'm going to ask this of the other two
Sure.
witnesses, Matt and looks like David is on, but I just want to make sure that I understand your position. And from what I'm hearing is this would be a tool that in the long term would be beneficial as well as just now during this emergency.
That's my sense.
Okay.
And I think I've heard that from other judges as well. If you think about it, and I'll stop talking, you know, there's been talk in some of the committees about the so-called second look. You know, look at a sentence long after it's imposed, see if it still makes sense. This might be a vehicle. Thank you.
Okay.
So this, okay.
I'm sorry, Alice, did you have a question?
I was just wondering, yeah, okay. We're having another witness, right? I'm assuming.
We have 4 more scheduled.
Okay.
Matt Valerio, David Shearer, John Campbell, and Dale Crook.
Okay.
Okay, Matt?
Yeah, I'm fine. You hear me?
We can hear you.
Yes.
Okay. I'm glad it worked out. So thank you for having me. We're actually a little surprised that this sentence review consideration is the thing that's drawing all of the attention compared to the other things in the list. I've spoken to the judge about it, and we've in the past spoken with state's attorneys and the Attorney General's office about a modification that would make it explicit to give the court authority to modify sentences based on agreements between the defense and the prosecutor. This in the past has arisen many times, and it arises oftentimes when post-conviction relief cases are filed, and as part of the settlement or resolution of those cases, the parties, both the defense and prosecutor, agree upon a modification of the sentence. I've never seen one where the sentence goes up because it requires the consent of the defendant to do it. And some judges feel like they have the authority to do that based upon the agreement of the parties to vacate the prior sentence, to modify the sentence that is there, or to restructure it in some way based upon the agreement of the parties. Other judges don't feel like they can do that because they didn't feel they had specific authority to do it. And so what ended up happening is people would judge shop. They'd find the ones who would sign off on them and try to get the cases filed in the counties or the like, where those the judges who were amenable to signing off on these agreements would be. And some of the judges that I am aware of who did not feel they had authority lamented the fact that they didn't believe that they had the authority to sign off on these agreements. Now, that's in the general practice of things. Currently, the virus crisis has put us in a position where there are people who, as the judge suggested, are doing quote unquote dead time. That is, they might have a year or less on their sentence. They are left to go, whether it's on their minimum or on their maximum. And they have no programming that's required left of them, or there is no programming available for them on the inside. They're considered low risk, but because of the structure of their sentence, they are not releasable. So one of the ways to get at that is allow the prosecutor and the defender to agree to modify the sentence to allow for immediate release. And that's how this section applies in our current situation. So we're in favor of it. Based on prior conversations, I understood in speaking with Marshall Paul, Deputy Defender General, about this. We had agreements with the excuse me, the state's attorneys and with the Attorney General's office that this would be something beneficial for everybody. So as to that first issue, that's basically, I'm willing to take any questions on that. Okay. I'm running two screens here, so I'm pulling down.
Dick, you need to unmute yourself.
Thanks, Joe. Any questions for Matt about the modification or changing the sentence? Reduce or modify the sentence. Okay. Matt, did you want to cover the other criminal?
Yeah, and I did want to, well, the Rule 35 is obviously the same as the statute. They're just mirroring it. Regarding the physical appearance of the defendant, if the defendant has the right to waive that appearance and appear telephonically, this is something, frankly, we've been asking for quite some time, particularly for clients who have to come from out of state, take time off from work, that sort of thing. And so, again, this arises in the context of our emergency situation, but it also makes complete sense to have it be the case even when it is not in an emergency situation, and we support that proposal as well.
On the bail review?
Now, normally this would be one we'd kick about, but we also understand under the current circumstances that there needs to be some leeway, and there are some specific issues involving bail and incarceration right now that have arisen under the law involving the conditions and availability of being able to respond to the virus situation. There's been scores of these motions filed and literally tens of thousands all over the country based upon U.S. Supreme Court and circuit case law that I believe are now, the decisions are not being consolidated, but the review of the kind of the science and the status of the general affairs of corrections' ability to respond to it have been consolidated into one case or under one judge. up in Burlington. And so we don't object to this at this point. And we're also seeing, by the way, many less people being held on bail right now, particularly with regard to misdemeanors and nonviolent felonies than we had in the past. And the numbers that I got this morning regarding the detention population are lower than I've ever seen.
Good.
Down close to 300.
Wow.
At this point. So it's a wonder sometimes that you might be able to make some good observations about what comes out of a crisis. So we don't object to that. I would note, and although on the mental health section, I'm sure legal aid will have a testimony about this section if they haven't already. That regarding these kinds of things, the days, the time frames tend to be dealing with health issues as opposed to any other thing. And we, I understand the situation, but we would not want to see, if we had someone going in to a hospitalization hearing or the like, and as part of this treatment protocol, for them to not have access to these hearings indefinitely while they're being held in the custody of the Department of Mental Health. Now, again, regarding civil suspension, the next section, the Defender General's Office typically does not do civil suspension cases unless there are crossover issues in the criminal case that deal with suppression. However, for example, in a DUI 2, the person's license is immediately suspended upon receiving the citation, and to allow the waiver of timeframes indefinitely in civil suspensions effectively revokes their license indefinitely. We would suggest that if the timeframes for the final hearing are waived indefinitely, that the license suspension should not go into effect immediately. And we understand the pressure on the judiciary, and because we're seeing it as well as anybody, but really it allows for the revocation of a license indefinitely without process. And we would suggest that there, aside from just waiving the hearings, that license should at least still be in effect pending the hearing.
Okay, Bryn, did you get that? Bryn, I think just the draft person.
Yeah, I did.
Okay, thank you. Thank you.
Regarding expungement and sealing, expungement is a much more difficult process. As far as sealing, if those are eligible, I didn't know that there are some that are automatically sealed. So to me, it would be just be making an entry. So I don't know the process, and maybe the judge could help a little with that. But I understand regarding expungement, delay those timelines. But regarding sealing, I thought it might be easy enough to do if it's effectively some of the automatic sealings that occur.
Who was just unmuted?
It's gone away.
That was me. I'm trying to work something out with Senator White, because when she has her phone on, that's where we're hearing the echo, but when we don't, we can't hear her. So Senator White, can you try now to talk? Ugh. Yeah, we're having some real issues with her, unfortunately, but that did not work.
Judge,
right.
did you want to comment?
We're talking about the expungement and sealing. Even when we say even when we say it's automatic,
You are unmuted.
it still requires an entry, as Matt has said. But the problem we have is that our staffs are substantially reduced and getting more so each day. We had to at least suspend operations in one civil court because we were down to one staff member. So our concern is that even making entries it takes staff time, and we're just limited. I'm not suggesting that we wouldn't continue to do it, but trying to do it in the timeframes that are called for is what the problem is.
I will say that of all the concerns or any of the issues that I've raised regarding the entire document, this is the least of them.
Thank you. All right. Any other questions? Any questions for Matt from any of the committee members? Thank you, Matt. Appreciate you. Nice. Now the next witness is David Scher from the Attorney General's office. David?
Thank you, Senator. Thanks for having me here today. Good to see you all. With respect to the first proposal in the judge's memo, the after the fact review of sentences, or the after 90-day review of sentences, the Attorney General certainly supports that. It seems like a common sense provision if both parties and the judge agree that a sentence is no longer necessary or should be modified downward in some way. It certainly seems like there ought to be a provision to do that, and the Attorney General supports that. I think it leaves state's attorneys and the Attorney General enough discretion. Really, it leaves them complete discretion to make decisions about issues like trying to weigh issues of finality or victims issues. Those things will all certainly still be within the purview of state's attorneys and the Attorney General to consider. So we think that there's sufficient protections here, and we do support that provision.
Just a question that comes to mind, and I guess it'd be also for John Campbell or Pepper. Would this run into a number of people saying, oh, hey, wait a minute, I want my sentence reconsidered? How would you handle the, frivolous cases?
I think we can expect that there will be a decent number of requests. But the reality is that there's no way to force anything into court without the agreement of the state's attorney or the Attorney General. And the prosecutors involved can make essentially a summary decision not to consider something if they don't believe that it should be considered. So I don't think that it will unduly burden prosecutors who are trying to work on these cases. If they don't agree that something should move forward, they can simply not respond. And there's nothing that requires them to do anything more than that. There's no motion that forces this into court. It has to be by stipulation. And I think that leaves sufficient, at least state's attorneys and the Attorney General with sufficient authority to simply not act where they think it's not appropriate and will not impose excessive work.
Can I ask a question?
Yep.
Thank you, David. I'm wondering if I'm understanding correctly, could it be done with either the Attorney General's okay or the state's attorneys? In other words, could one of them disagree, but you still have a modification?
My understanding of the proposal is that it requires both. With the and conjunction there, state's attorney or Attorney General and defendant. So you really need a stipulation that has both parties. I would certainly defer to Judge Grierson on the legislative, well, I shouldn't say legislative, but the intent of the memo in terms of what he was thinking on that. But that was how I read that language.
Let me just chime in here. First, in response to Senator Sears' question about would this have a significant impact, we already get a number of requests from individuals incarcerated filing them pro se, just, I want my sentence reviewed or changed. And the court sees those now, and if they're beyond 90 days, our entry is simple. There is no basis to modify a sentence after 90 days. So we see those anyway. I don't see this as having a significant impact. To go to the other question by Senator Baruth, the way I envisioned it, and maybe it needs some clarification, it says state's attorney or the attorney general and the defendant. It clearly requires the agreement of the defendant and the prosecuting attorney. If the sentence if the case was prosecuted by the state's attorney, they would be the one that would have to agree to a sentence reduction. On the other hand, if it's a prosecution that was handled by the attorney general's office, then they would be the entity to agree on a reduced sentence. I would not, and I certainly didn't envision all of a sudden the attorney general's office agreeing to a reduction of a sentence that was prosecuted by a state's attorney. So if the language needs some clarification, that's certainly what I had in mind.
Could I?
So that raises another question, Judge, and David also. There was a state's attorney in Chittenden County following the situation in Chittenden County at the jail who reviewed a number of sentences and was able to reduce those sentences or take the jail. Was that because the judge was willing, or is that because they were within the 90 days?
I guess I'm not familiar with the cases, Senator, but it.
Well, I'll wait for John Campbell on that one.
Right. I don't know, because I don't know what the specifics were.
And
on the other.
Do you mind if I say something?
Go ahead.
In looking at this, the Attorney General and the state's attorneys have concurrent jurisdiction over all criminal cases. The AG can decide to pick it up. The state's attorney, they can basically take the case away from a state's attorney if they want to. As I understand it, that rarely happens. But what also happens is that these cases may be brought by the Prisoner's Rights Office post-sentencing, and they are dealing with DOC legal, which is part of the AG's office, so to speak, or an AG in the AG's office. So it doesn't necessarily require the intervention of the state's attorney who did the sentencing to begin with. And oftentimes you might not even have the same state's attorney in office, or deputies or anybody around who did the case. So it's being handled by different people completely. And my understanding of this and the way it's handled in the 90 days is that whoever ends up the case, this just ends up having the case for the prosecution or for the defense. It gives them the authority to effectively settle the sentencing issue if it's appropriate.
Okay, thank you. Any other, David, did you have comments on the other sections? David, you've muted yourself or somebody.
Oh, whoops.
Muted.
Here we are, I think. One thing I wanted to add briefly on that point, I did interpret the language. I'm sorry if there's any confusion here. I think I might not have understood the question, but I interpreted the language the way Judge Grierson interprets it, which is basically it requires defense and prosecution to agree. And I think Matt Valerio is correct. Sometimes cases do switch between offices. That's generally been or it has been a sort of matter of discussion between state's attorneys and attorney general, but whoever is working, whatever entity from the state side, whether state's attorney or attorney general, has been working on the case would be likely the one to work on this issue if it were when requests arise. And on the sections to follow, we don't have an objection to extending timelines. I would say that the extension of the timelines should be clearly, our preference would be for them to be tied to the emergency. And if there needs to be a period after the emergency for catch up, that's fine too. But that was my only comment on the timeline issue. Otherwise, we didn't have anything further.
Okay. Are there other questions for David? Sure. David, thanks for joining us.
Thank
Appreciate
you.
it. John Campbell?
Could I just make? Oh, okay.
Yep, go ahead. This Alice?
Yeah, I'll wait and listen to John before I say what I was going to say.
Okay, John,
Can you hear me?
we can hear
Yes.
you. We wish you
If I
could
could
see
first
you.
tell- I would first like to tell Senator Benning that I now know what it's like to be in the minority, and I empathize with you. It seems that I might have a different position here on this. First of all, thank you for letting us talk about this, and I want you all to know that since this COVID-19 outbreak, we worked very closely with the Defense Bar, with DOC, and with the courts to help reduce the detainee population, and also the ones that are coming into the system since then. And I think there's been a significant drop in the detainee population, which was alluded to, and we continue to do that. With that said, I look at this language, and knowing that it existed prior to COVID-19, I still believe, and I very strongly, that there's nothing emergent about this situation and this request to change Rule 35 and also Title 13, 7042. And this is what's being asked here is to change what the rule is regarding sentence reduction by a court. And that's an absolute extraordinary power for a number of reasons. But more importantly, and probably most importantly, I think people are forgetting about the victims here, and the fact that when a person is sentenced, they believe that that person, that's what they're getting. It's when the community believes what the sentence is, and people feel like they have closure, they can go away. What if you allow this now past the 90 days? What you're doing is saying that any sentence for anybody, any crime, any criminal act is open for consideration again. Even if and right now they're open for only for certain reasons if they can be shown that there's defects in the prosecution or whatever. But now it's open. It'll be open for as long as that person is incarcerated, or for their life if they're in there for life. It doesn't. It's not restricted to anyone, any specific type of crime. Second of all, I strongly disagree with the interpretation of what this language says, because if you look at it, it clearly would allow the Attorney General and a defendant to come to an agreement with the court, and even if it's over the objection of the state's attorney. It does not say anywhere about the state's attorney who prosecuted, or the case that if the case was prosecuted by the state's attorney or the Attorney General. It does not set out any of those specifics. And if this section D, or I'm sorry, E, I should say, it doesn't modify the entire section up there. So it's a standalone, and that is, gives it its own power there. If you were going to go through with this, and again, I strongly disagree. I think it's a bad mistake right now to do this. But if you did, there would have to be clarification of that language to say that it has to be between the prosecutor, or at least the office that prosecuted the defendant, and the defendant, not the Attorney General. Because in many cases, in almost every case actually, the Attorney General has nothing to do with these prosecutions. If the Attorney General wants to make a decision in a case that they prosecuted, that's fine. I understand that. But in the cases that the state's attorney prosecutes, they're the ones that know what the case was about. They're the ones that know the victim. They're the ones that know facts that may not have been able to be introduced in trial. There's so many factors that come into play of knowledge that must be looked at when you're deciding whether to reduce somebody's sentence. And again, going back to the emergent side of this, is this, if we're dealing with this just because we're worried about people being incarcerated and also being exposed to COVID-19, then we're saying that our prisons are pretty much going to be exposed, or the prisoners are being exposed to COVID-19? Or else is this the only reason why we're letting them out, because we don't want them to? And as we already know, and this has been discussed in this committee and other committees already, is that there's a lot of times when people that even if they were released, they have no place to go, they have no housing whatsoever on the outside. Again, I just don't see this having anything to do with the COVID-19 emergency that we're facing. I think this is something that certain groups of people wanted to have passed, so they have a second chance, a second bite of the apple, if you will, to change a sentence. And
Can I interrupt to just ask you a question, John? And certainly we can amend the proposal so that it's clear that it's the either the Attorney General, or it's the person who prosecuted, or the office that prosecuted the case. But is it true that in some cases judges allow modification past the 90 days and others don't? And you have a, again, an unequal justice system depending upon the view of the judge. And that concerns me, that one could judge shop, and if you're the state's attorney, and let's say that you're a Rutland County state's attorney, and you defeated your this prior state's attorney, and you just felt strongly that one of the convictions that he got, or the sentence that he got, was unfair. Could then that state's attorney, the new state's attorney, take that case and agree to a modification? Would that be such a bad thing? I mean, they're independently elected, so.
No, I understand that. And, you would have to, again, I don't know about that, and I'll be straight with you as far as the process. I don't know what the process would be. I think the only way, and Judge Gershon
I can use another example. Let's say you were elected in Chittenden County. I mean, you were appointed as a Chittenden County state's attorney because the former state's attorney became attorney general, and then you saw what happened at Burlington, at the correctional facility in South Burlington, and made changes with that. I mean, that's.
I think what it comes down to is that, I believe that we probably have a state's attorney who would love to be able to work with the defense and modify sentences in our existence right now. And that state's attorney, that would be their prerogative under, if this was passed, to try to review sentences. Unless, of course, it came to a situation where they knew that let's say the individuals that were prosecuted under prior state's attorney, if there was some something illegal that happened, or some evidence that did not come to light, I'm sure that there's a way for them to present that. But the bottom line, I think, is what concerns me. What concerns me is the fact that you have an office. You're dealing with cases where the victims and the communities believe that there are people who have been incarcerated, who went through the trial process, received a sentence, and that now, if this is passed, that is always still up for change, and it leaves an uncertainty there in their lives. Again, if it's the prosecutor if it's the case is in a county, and the prosecutor or his deputies or somebody in the office or the people in the county are very well aware that an individual might pose a serious risk to them or the community, and they would object to the person's sentence being reconsidered. But then you have an attorney general who does not live in that county and might think, oh, you know what? I just don't think it's fair. I feel that everybody deserves a second chance, and then agree with the defendant and the court. So you are taking it out of the hands of the actual office that lived through the investigation and the prosecution of these individuals. And by the way, just to make sure that you are aware, I am not contesting that the fact that the Attorney General has concurrent jurisdiction. However, that has always been a very well respected line, and we're talking about situations where clearly the state's attorneys now and our Attorney General, there have been many cases or many issues brought before your committee where that we're not always in agreement. So I think that
let me make clear, John, I haven't made up my mind here whether to support this or not support it. My concern is that some judges do it, some don't. And so you have this, as Matt, I think it was Matt, or said something, or maybe it was David, said something about judge shopping and that sort of thing. And that just leads to more unequal justice, and that's my concern.
Okay, so I heard Matt. I didn't hear how he was saying that they were doing this. Maybe he can chime in here. But one thing, let me just get back to Matt, is that he said something I want to clarify. He made a statement that either he or Marshall, I guess, have been talking with the state's attorneys, and they feel that this would be beneficial. I can tell you emphatically that is not the case. I have spoken with the attorneys. I don't know who he's talking about. It sounds like he was talking about all these state's attorneys, and I can assure you that as of yesterday, when I spoke to them all, they did not. None of them were in support of this. Of this, and so I don't know where that's coming from. So maybe you can clarify that.
Okay, Matt.
Yeah, these are issues that have come up. Basically, it's the state's attorneys who have been rejected when they've attempted to resolve post-conviction relief cases that are by stipulation. I know that some of those have come out of Chittenden County. I know that there are others that have come out of Windsor County in the past, there are, I don't think you have a uniform group there by any means, and I understand that. But clearly one of the things that happens if you have a post-conviction relief case that involves whatever it is would be the basis for the stipulated resolution and a reduction in sentence, both sides are looking to get it off their plate and to move on. In any of those cases, I have never seen or heard of one if a victim was involved where they were not consulted. Now their advice may not be taken, but they were always consulted.
But the post-conviction relief cases, we're not talking about this here.
Well,
this is nothing like a post-conviction relief, because we're not talking about the ineffective assistance of counsel or some other matters that may come up that weren't raised earlier.
I didn't say ineffective assistance of counsel,
just
John.
Saying that somebody decides that the judge wants to revisit and reduce a sentence of somebody incarcerated. There's no rules or regulations around this. When they
John,
can,
I didn't
when
say
they can't,
ineffective
who it does
assistance
apply
of
to.
counsel. I didn't say ineffective assistance of counsel. I said modification of the sentence after the 90-day window. And that can come in post-conviction relief. And post-conviction relief is not always about ineffective assistance of counsel. It can be about prosecutorial misconduct of the police, the ability of having a legitimate plea agreement, the ability to provide the appropriate treatment or programming that was anticipated when they went into the plea agreement. There are any number of reasons why you might want to modify a sentence. And I'm not talking necessarily about ineffective assistance. All I'm talking about is that there are some number of instances after the 90-day window occurs where this might be appropriate. This virus situation has given rise to more situations based upon the department's ability to address the medical needs, and particularly the medical needs of people at risk in somebody's given sentence structure, where it would be prudent to release them. So that's why.
So DOC can do that through furlough. through the medical necessity of furlough, correct?
Medical furlough. The DOC right now has a proposed release protocol that is that you haven't seen yet, maybe, but I've seen, and it's a completely different issue. Furlough. In any event,
we're going to hear from DOC next, John.
Okay, well, Senator, if I could just finish again, I understand what Matt's saying, but what all the areas that he's raising for post-conviction relief, and I mentioned those earlier, not individually one, which he did, but that's what that's for. I mean, that's we have the post-conviction relief just to address issues like that. We're not what you're looking at here now is not that. This is totally separate from that. This is saying that if somebody just makes a motion, doesn't say what it's based on, that they want to after the sentence is imposed, at any time after the imposition of sentence, the motion can be made to reduce or otherwise modify the sentence. It doesn't say why, it doesn't give rationale, doesn't give limitations. So that's why I'm saying that this is so much bigger than what you all are being told about right now. So I really, really hope that you decide that this is something that is going to require further testimony, in-depth testimony that it should it cannot be had during this emergent period.
Okay. Well, we are going to take it up next week, and so and have more discussion about it. I can't remember what day. I think it's Tuesday. But did you have any concerns about other portions of it?
There's
suspension?
No objections. I think the only one that we have some comment on would be the expungement, and I'm going to turn it over to Pepper if that's okay, Senator, so he can because he handles the expungement matters.
Yeah. Well, I don't know if committee members had to leave at 2. We had Dale scheduled to hear from him. We're running a little late. Can everybody hang in for another 10 minutes?
Yes.
Yes.
Can we take up the expungement from Pepper next week and hear just quickly from Dale? That'd be all right,
Yeah.
John?
That's fine. Yep, that's fine with us, your Senator.
Okay. Dale, corrections view of this, and tell us a little bit about what's going on in corrections world.
Yeah, can you hear me?
Yep.
Okay, good. Really overall, in general, for the memo that came out from Judge Gerson, the department is kind of neutral. A lot of it is about sentencing and court processes that really doesn't really have issues with us. But at this time, in any situation in this emergent time, that would allow a sentence to be reconsidered to allow individuals to be released from the facilities, we would be in support of that. That's kind of the short of I think what Judge Gerson has, and I can open up if there's any questions about that. If you would like to know what the department's doing in general, I can brief you on that.
How many people do you have that you would have appropriate places to go that you could release if the sentence was restructured? Do you know?
I would have no clue on that. That's too hard. Too many variables to figure out.
Okay. Well, what are your numbers today?
This morning we're at 1,500 on the nose population.
So you've dropped about 150.
Yeah, give or take about 155 in the last 10 days.
Wow.
Yes.
Wow.
Some of our staff, both field and facility, have been just crushing it, working hard. The department is really trying to be mindful of our institute and the COVID-19, and that is kind of a huge priority for us right now. Everyone can imagine if the virus gets in one of our facilities, it's going to be really bad. So the department has kind of made some steps forward to look at reducing the look how we supervise in the communities, and really raise our tolerance for nuisance types cases, but public safety, victim safety, we're not changing how we supervise or respond to those types of behaviors. We've loosened up our residence restrictions. We're pushing and working with our transitional housing partners to kind of be brave to take cases on when they're still also at the time dealing with what everyone else is dealing with as far as COVID and staffing and trying to be spacing and social distancing. So far, it seems to be good.
Dale?
Yes, sir.
Yeah.
You said if the virus gets into any of our facilities, but I understood that it already was, isn't it?
We've had an admin. We have had a worker at Northern State test positive, but we have no confirmed cases of the inmate population in our facilities right now. So that is very good. And the individual that did test positive did not have access into the secure portion of that facility where the inmates are housed.
When you said that number, the 1,500, that's sentenced?
Total population, yes.
Okay. And there's still 236 out of state?
Yes, we have not moved our out-of-state population.
Okay.
Hey, Dale.
Yep, go ahead. I'm sorry.
I'm sorry, Dale, have you had any inmates tested? I know you may not have had results, but have you had any inmates tested who were demonstrating signs or symptoms?
I know we've had at least, and that test is back negative, that we had concerns that were showing symptoms. That is all I am aware of. Doesn't mean that we have not tested more. As we're having issues like everyone else is getting tests. So this is not really my forte. So I don't want to speak too out of line. We're letting medical determine. We have isolations if we have people that are showing symptoms that could or could not, cough, fever, things of that nature. We are separating and isolating. Having the reduction in our population allows us a little bit more flexibility and space so we can start isolating individuals better. As things progress and hopefully we can get more tests, ability to access tests in our facility, once we start seeing more symptoms, we're testing in order to isolate and separate the best we can.
I'm taking it from your answer that you have had people with symptoms who have been isolated.
Correct.
And do you know how many of those there are and where they are located?
No, I cannot, but I can try to get that information and send it. I don't have that information. I do know that we're trying to be that the facilities have their protocols. Individuals come in with a cough, or we have a screening. Everyone's getting screened coming in to our facilities. Have you been exposed? Someone that might have been, traveled. Kind of the CDC and the Department of Health questions that everyone should be asking when they're coming in and out of buildings. We're asking those. If people are answering yes, we kind of isolate them for the quarantine type period until they are past that, and then we kind of mix them back into the population. We are minimizing movement within facilities to not cross living units with other units in case that there is something in there. Facilities have really been with the CDC, not the CDC, but the Department of Health, and our Centurion, our medical staff, really sitting up protocols and implementing things. For example, no visits right now. We're minimizing people coming in and exposing anyone in the facility. So I know that the no visits are causing some heartburn for folks, but I think overall the population in general understand why we're doing what we're doing.
Thank you, Dale. I'm a little confused. I'm still trying to, I think it was 7 or 8 days ago, when we heard from Jim Baker, there was, or just before we left Montpelier, there were 1,600 and some odd people incarcerated in state. And so you're not counting, you're counting 1,500 people, including 307 detainees, right?
Yes, that is our in-state, that are total population. I can, let me,
And that includes the federal detainees, the state.
Yeah, I have the numbers right here for today.
Okay.
Total population, male, out of state, female, 1,500, of which 351 are detainees. The federal population is 42, I'm sorry, 44 detainees. Male detainees, 307. Total state detainees, 300.
total
And the
307.
includes the out of state and the state.
So 307 and 44, and then 230,
right?
Something outstate.
Yep.
Good.
Yeah. I don't ever recall being that, since I've been in the department, I don't think it's ever been that low.
Other questions for any of our witnesses? And thank all of you for being so patient with us. And John Campbell, thank you for being patient and letting us take Pepper up next week.
No problem.
And hope everybody
Take them for as
stays.
long as you need them.
Well, and thank you all, and hope you all stay safe and healthy over the weekend. Try to get out into the beautiful outdoors. It's supposed to rain tomorrow, Sunday, so take advantage of tomorrow. Have a good week.
You too. Thanks.
Thank you.
All right, I'm going off the record with this.
Thank you.